Hi, everybody. Thanks for coming. I really appreciate it. Wanted to really go over the report on improving mental health outcomes and its implications for the PAMI program. So, a little about me. I was hospitalized in 1982 for a month and was lucky not to have been made permanently mentally ill by the system. I was told, well, I was told the best I could hope for was, to minimize the amount of time in the hospital, and I didn't really have much in the way of further life prospects. So, and my perspective is the system does that to a lot of people. It's kind of a abandon all hope ye who enter here type of approach, for people who end up in the hospital. And it changed the trajectory of my life. And in 2002, I founded a law project for psychiatric rights to mount a strategic litigation campaign against forced psychiatric drugging and electroshock. And that was as a result of reading Mad in America by Bob Whitaker, which to me, in addition to being a fabulous book, was a litigation roadmap for how to challenge forced drugging, not based just on the civil rights aspect of it, but it not being in people's best interest. That was in 2002. In 2010, he wrote Anatomy of an Epidemic, and that I think has had more impact, but it was Mad in America that got me going. So, and about, a little over 2 years ago, this report on improving mental health outcomes was published, and I was the lead author, and it basically is the culmination of all the research that I've accumulated over the years. And there's some distinguished co-authors. Peter Gertsch is one of the top medical researchers in the world. David Cohen is one of the top researchers on psychiatric drugs. Chuck Ruby is executive director of the International Society for Ethical Psychology and Psychiatry. And Faith Myers was the client in my first Alaska Supreme Court win, and a really fabulous advocate. But basically the situation is that the current system is reducing the recovery rate from a possible 80% to 5%. It's shortening people's lifespans by 20 to 25 years while catastrophically diminishing their quality of life. And I'm basically talking about the neuroleptics, which are marketed as antipsychotics, even though they don't have antipsychotic properties for most. One of their original names, in addition to being a neuroleptic, which means sees the brain, is a major tranquilizer, which was to contrast them with the benzodiazepines, which we called minor tranquilizers. And so that's basically what they do. They kind of disable people so they can't be so disturbing. So, and contrary to popular belief, psychiatric drugs increase harm to self and others, and psychiatric imprisonment or confinement is massively associated with suicide. So the idea that you lock people up because they're, to prevent them from harming themselves is basically is insane. I mean, it's just the opposite happens. And this is all, and there are other approaches that have been proven to be effective, safe, and non-coercive. And all of this is documented in the report on improving mental health outcomes. And this is just a sample page. And the reason why I wanted to do that is you can see the footnotes. It's completely referenced. But also there are links to the actual sources. So people, you can check out. We're not afraid to be challenged, and no one has challenged what is in this report. Anyway, I can say more about that, I guess. And I wanted to go just through a little bit on this, the reduction in the recovery rate. These slides are basically from Robert Whitaker, the author of Mad and American Anatomy of an Epidemic. And what we see is this huge increase in the rate of disabled mentally ill in the United States since the introduction of the so-called miracle drug Thorazine in 1955. I'm sorry for my slurring, but I lost a tooth and I can't, so I'm having trouble with some words. And so it's basically gone up 8 times, or I guess 6.5 times. It was 8 times. And I don't think all of the increase between 1987 and 2013 was because of the drugs. I think some of it was that the welfare to work requirements came in during that period. And then the reduction was because it became harder to qualify for disability in that period of time. But there has been this huge increase in people diagnosed with mental illness and that being the reason that they're registered as disabled. Okay, so this is a naturalistic study of long-term recovery rates for people diagnosed with schizophrenia. Actually, it's also, I think, anyway, it's people with psychosis and put on the neuroleptics or antipsychotics. And it basically shows a long-term recovery rate of 5%. And this is worse than anything than before the drugs were introduced. And this slide shows basically from 45% to 88% good outcomes. This is basically before the drugs were introduced. And then there was this, I think maybe a lot of people know about the open dialogue approach. And this is the results of the 5 years of study of that, where basically 80% of the people recovered. And their approach, first off, their approach basically is that the problem doesn't reside in the identified person, but the spaces between them, and they have this very well-developed technique they have 2-person teams. They show up within 24 hours of being called, and they work with everybody in that person's close orbit family, mostly family, maybe coworkers or students that they're in class with. And they try to avoid using the neuroleptics as much as possible. And so their results were that 79% were asymptomatic at 5 years. Only 20% were on disability. And interestingly, there's only 20% that had ongoing use of the neuroleptics at the end of 5 years. And I'm not saying there's 100% overlap between, the 20% that aren't showing as recovered and those in the ongoing use, but obviously I think it's pretty close to that. And so the Soteria House study in the 1970s by Loren Mosier, Alma Men, and Voice Hendricks. Loren Mosier was the head of schizophrenia research at the Institute of Mental Health at the time. And they had this approach where they, and it was a randomized study. People would show up at the hospital and they would either be assigned to the hospital or assigned to Soteria. And it was a home-like setting. The expectation is people would get better. They really avoided giving people neuroleptics initially. And they basically had, I mean, I could say more about that, but I don't, and I'm happy to do it at another time or maybe later today, that only 19% were regularly maintained on the drugs during follow-up. So these studies, especially open dialogue and then also the Soteria House study, is where I come up with the 80% possible recovery rate. And that same study by Harrow and Job, they compared people who were on the neuroleptics or antipsychotics and off the neuroleptics or antipsychotics. And if people got off of them, they ended up with a 40% recovery rate, as opposed to the 5% if they stayed on them, which is 8%, 8 times better than 5%, but half of 80%, which really shows how important not putting people on the neuroleptics in the first place is. So I think this is the background for the PAIMI Act, which of course stands for the Protection and Advocacy for Mental Illness Act. And there are two statutory purposes. One is to ensure that the rights of individuals with mental illness are protected, including ensuring the enforcement of the Constitution and federal and state statutes, and also to investigate incidents of abuse and neglect. But I'm really focused on enforcing, ensuring the rights of individuals with mental illness. Okay, so involuntary commitment is permissible under the U.S. Constitution when confinement takes place pursuant to proper procedures and evidentiary standards. There's a finding of dangerous either to oneself or to others, and that dangerousness is basically a result of a mental illness or mental abnormality. And being unable to take care of oneself can constitute danger to self. And the state has to prove this by clear and convincing evidence. And when that case came up to the Supreme Court, the argument was made that, it's locking people up. You should have to prove it beyond a reasonable doubt, just like you do in a criminal case. And the Supreme Court said, well, they could never prove it beyond a reasonable doubt, so we're not going to require that, which, I think is an interesting way to look at it. And then forced drugging. This United States versus Cell was a case where the government wanted to drug this dentist who was accused of fraud, probably Medicaid fraud, to make him competent to stand trial. So it's not exactly the civil context that we're most used to. But they found that the court has to conclude, again by clear and convincing evidence, that there's an important governmental interest at stake. So in that case, if the person was accused of jaywalking, well, is that important enough for someone to be, drugged against their will? Probably not. I think the Medicaid fraud is somewhat questionable, but in fact, I can't even remember where they ended up on that. I think they sent it back to the trial court. And So it has to have an important governmental interest. It has to significantly further those interests, is the way they describe it. But another way to put it is that it's got to work, and they can't have side effects that will interfere significantly with achieving that result. It has to be necessary to further those interests, and the court must find that any alternative, less intrusive treatments are unlikely to achieve substantially the same results, and that it's got to be medically appropriate, i.e. in the patient's best medical interest. So this is pretty classic, what's called substantive due process analysis. And I think, and there are state cases that have basically held this applies to forced drugging. I won one of those cases in Alaska, the Faith Myers case, and she's a co-author on the report. And I think my view is this is what's required under the United States Constitution. This U.S. Supreme Court has not specifically held that. Other state courts have. Okay, so no more than 10% of psychiatrically confined people, either involuntary, basically involuntary commitment, actually meet the commitment criteria. And I could go into why that is, but anyway, I don't know if people know the name Michael Perlin. He was a professor of mental health at New York Law School. He was kind of the preeminent scholar on mental health law, and previously did that work as the head of the public defender office in New Jersey. And he agreed with me that was true. And in my view, no one can ever properly be drugged against their will under cell, because you've got to prove it's in their best interest, which it's hard to say that it's in their best interest if it's going to reduce their lifespan by 20 to 25 years and reduce their chances of getting better from 80% to 5%. And there are less intrusive alternatives available, which are gone into in the report. So this is the setting for PAIMI. I think people know the advisory council membership is supposed to, have all these types of people: attorneys, mental health professionals, individuals from the public who are knowledgeable about mental illness. And then, interesting, it says a provider of mental health services, and then individuals who have received or are receiving mental health services, and family members, of which 60% of the council has to be people who've received mental health services or family members. And the council has to be chaired by such an individual or their family members. So this is one thing that I think there's some confusion about. The statute says that the advisory council will advise its protection and advocacy agency on policies and priorities to be carried out in protecting and advocating the rights of individuals with mental illness. So there is this huge, sometimes emphasis on that the council is only advisory. Well, it is advisory, but what does that mean? The statute says that the advisory council and the protection and advocacy agent jointly develop the annual priorities of the system. And so I think jointly means that they have to agree. Or another way to look at it is that the advisory council has a veto, and the protection advocacy agency has a veto, which is another way of saying they have to agree. Anyway, I think there's some kind of this emphasis on advisory kind of diminishes the true authority of the advisory council. And then the regulations say the same thing, that the P&H shall jointly with the advisory council annually establish program priorities and policies. And the advisory council must provide independent advice and recommendations. And so, for example, in California, the P&A was selecting who were members of the council, and SAMHSA came and said, no, the P&A can't appoint the members of the council because that doesn't make it, then it's not independent if the P&A appoints the council members. And again, they say work jointly with the governing authority in the development of policies and priorities. So in light of the massive amount of harm that psychiatric confinement and forced drugging are causing as a result of what I would call pervasive rights violations, and the purpose of the PAIMI Act, at least the first purpose, is to ensure the rights of individuals with mental illness are protected. That the priority, I think that the highest priority, certainly a high priority, should be to protect the rights of people to not be psychiatrically confined and or drugged or electroshocked against their will, unless the constitutional, statutory, and judicial requirements for such massive deprivations of liberty exist, including the right to the least restrictive and least intrusive alternative, respectively. So I've got a few more slides, but that's kind of the key to it. The council is entitled to information about the budget and other things. There can be training money provided to it. Oh, and then I think people know there needs to be an opportunity for the public to provide input. And then the advisory council is to prepare the annual report.